All right, let's call Nelson Cajas.
Thank you, Your Honor.
What's that?
Mr. Cajas, step up to the podium. Excellent. Your attorney is present.
Your
Your attorney is present in court, Mr. Cajas. You're here today for, you're accused of felony battery. Do you have any arguments?
Yes, Judge. We've spoken, the state and I, and come to a proposed bond for the court's review. It's $5,000 cash bond based on Mr. Cajas' very limited criminal history of convictions of any kind. It's all misdemeanor cannabis and traffic infractions and traffic criminal.
The state, no objection?
No, 5,000, no victim contact, no objection.
All right, the court's going to find probable cause, order bond in the amount of $5,000, order no indirect or direct contact with the victim in this case, and must stay at least 500 feet away from the place of employment, home, and school if it's applicable. Do you understand? Yes? Excellent. Also, if you have any weapons or firearms, you must surrender them to the nearest police department and provide a receipt of same to the clerk of court. Good luck to you, sir.
Thank you, Your Honor.
Thank you. All right, so Keisha Cunningham? Where would Miss Cunningham be?
Ms. Cunningham.
Northborough.
Thank you. Good morning, Miss Cunningham. You're here today. You're accused of petty theft. The court does find probable cause. State, what say you? Any objection to standard?
Ms. Cunningham, I'm not gonna ask for any increase or anything.
All right,
Your
Mr.
Honor,
Reedy,
Ms.
any of-
Cunningham indicated to me that she believed her mother had posted her bond. I don't know if confinement status has any update on that.
All right, well, at this point, the court's gonna find probable cause, put bond in the amount of $100, subject to review if necessary.
All right, I'll call your mom, Shakisha,
Thank
make sure
you.
she comes to get you, okay?
Good luck to you, Miss Cunningham. Andrea,
check
Cicely Andrea Mack.
Whitehead for me, Brenda Whitehead.
Good morning. You're here today accused of trespassing. Court finds probable cause. Is bond,
Your Honor, just, I'm fine with the bond where it is. I'm just asking that the court not resolve the matter. Ms. Mack has been here, I believe this is her, yes, fifth arrest, well, actually, 5th arrest this month. It's trespassing at the same location every time, causing disturbances. Every time she gets a plea offer, the judge says, don't go back. She tells the judge, I won't go back, and then she's back here.
in light of the fact that it's in the same location, I would like to hear from the victim's input on this particular case of defense. Anything you'd like to add?
No, Your Honor,
All right,
there
court
is
finds
nothing I
probable
would
cause.
like to add.
I'm gonna leave bond in the amount of $100. I think that's generous. Good luck to you, Miss. Karina Caraballo. Or Carballo.
Medio.
Thank you.
Your Honor, on Karina.
Good morning, Karina.
No, this is not Karina, this is Free Pro.
Oh,
Yeah, her family is
She
on
was
the
saying
way
it to you.
regarding Karina.
Okay.
They want to address the court, so if you don't mind.
all right, Karina, I'm gonna put you on recall because I've been told that your family's coming for you, so I'll wait to listen to them. If the defense has no objection, it's up to you.
That's
What's
fine.
she here for?
Okay.
Oh, yeah.
Brenda Whitehead. Oh, good morning.
Anything else?
Any
Anything
arguments,
outside?
PC? 'Cause
Well, I guess there's PC in the probable
All
cause,
right,
Judge, so I
court
can
finds
agree to
probable
that. One thing that's missing from the probable cause affidavit is all last week I spoke with Detective Farnoli, and I arranged that my client surrender 10 a.m. yesterday, and that's missing. So I want the court to
Okay.
know, that she did surrender. They gave her the weekend. There were no troubles. We believe this is one of those cases where I firmly believe it didn't happen. I just received some text messages that show that there's a history between these two families for whatever reason. While there's PC, Judge, I would say there's no evidence, there's no independent witnesses. There's some kind of bad blood between the families. It's a Hatfield and McCoy's, and they're maintaining that she pointed a gun. My client was never found in possession of a gun.
All right, at
There's
this
no
time,
evidence of it.
State, what is your recommendation?
Your Honor, based on, first off, just to advise the court, and they are dated, but she pled a 2001 felony out to a battery, theft in 01, carry and conceal firearm in 1995, where she violated her probation. Failure to appear arrest in 2004. Based on the allegations, Your Honor, state would be requesting a $15,000 bond, no victim contact, with an additional release condition that Ms. Whitehead not be in possession of any firearms or weapons until further order of the court.
I can tell you she can't afford that. She and her husband and their family, they're putting together some money. I've taken a very small retainer on the case. He works locally. He's a garbage man. He drives a truck, can't get here this morning. I spoke to him. Family's
They own a
concerned.
home?
I had, Judge, I forgot to ask him that. I apologize.
She doesn't own a
She's
vehicle.
48 years old. She's been in Florida her whole life. She surrendered. So she's not a flight risk. And that's, in terms of a high monetary bond, we're really concerned about flight risk. She's not going anywhere.
Well,
How much bond do you think they could afford, a $7,500 bond?
Yes, Judge.
Court's gonna put bond in the amount of $7,500. I do find probable cause. I'm gonna order no contact, direct or indirect with the victim. You must stay at least 500 feet away from the victim's home, school, or work. And you must surrender any weapons or firearms and any weapons permit that you have to the local police department and provide proof of same to the clerk of court. Good luck to you.
Thank you, Your Honor. Nice to see you.
You as well. Deborah Rogers?
Michelle.
Where's Deborah Rogers?
Should be main jail, Your Honor.
Okay. I can't hear you. I can't hear you.
Okay, but we can't hear even if you put your tongue.
Press it again? Yep. Oh, nope. Not at all.
Holding it closer, nothing to do.
I have system on.
We have this.
Oh, hold on. There we go. Okay. That was, I had the button picked.
Hello?
I can hear you.
We got you,
Can you hear
we
me
got
now?
you. Yes.
Okay.
Oh, what we were saying, Judge,
Now I had
is
to
she
turn it
couldn't
down.
hear you, what happened. I believe your microphone is too far away from you, so she couldn't hear what happened.
Okay. The bond was set at $7,500, and you've been ordered not to have any direct or indirect contact with the victim in this case, and you must stay at least 500 feet away from the victim's home, school, or work, and you must surrender any weapons or firearms that you possess, and or any weapons permit if you have one, and surrender to the nearest police department. Provide a proof of receipt of that with the clerk's office. Do you understand?
Yes.
All right, good luck to you. Thank you. How do you do them? Okay. All right, Deborah Rogers?
Ms. Rogers, come on up. Judge, she informed me she has private counsel. She doesn't remember the name, but I believe she said her family hired and he entered a notice of appearance.
Okay, Ms. Rogers, your counsel isn't present here today. Would you like, can you see if there's a notice of appearance on Ms. Rogers?
Your Honor, yes, I will check.
So at this point, I'm gonna put you on recall to see if we can get a hold of your attorney. If not, would you like us to reset you for tomorrow morning so he can be present?
For tonight? Is
Well,
it possible for tonight?
Well, we don't do tonight, we do the afternoon. We can try to get a hold of him. I'm just saying if we can't, I'm gonna try to get a hold of him this morning. If not, we can put you on for the afternoon. But if we still can't get a hold of him, I can put you on for the next morning.
Another question, Your Honor. What if I post bond?
You can always
Well,
postpone,
you're-
but
you're-
at this point, we're having a hearing.
Yeah, and the issue with that, Your Honor, I see no notice of appearance.
Okay.
And I was, frankly, based on the allegations.
Okay.
I was planning on making a bond increase. What I would ask the court to do, if the court finds PC, if the court could,
Well, I don't want to do anything at this time because she's unrepresented, so let me start with this. Ms. Rogers, at this point, the attorney has not filed a notice of appearance. This is a hearing for determine whether or not there's probable cause for your charges and for the court to set the bond for your release. So it would behoove you to have representation from counsel. At this point, do you wish me to postpone this for you to hire counsel and have them appear? Or do you wish to be represented by the public defender's office, which is present today?
No, but like reschedule for tomorrow.
Okay?
Your Honor, if I could just be heard, I'm just gonna request the court to make determinations even without prejudice. My reasoning is that, I believe and I would make argument, but I believe the bond should be increased, and I don't believe
Okay,
Ms.
but I don't believe that I can entertain your argument without her being represented by counsel. That is her right. So at this point, the court's not gonna make any decision until she has counsel representing her, and she's entitled to confer with counsel prior to this hearing, and therefore, what I can do is I can try, in an abundance of caution, to reset it for this afternoon. Can you, who is it that you, believe is your counsel that we can call them to see if they can appear?
I'm so sorry. I know I do have an attorney, but I don't know his name.
I'd
Okay.
be willing to call her family if
Who
she has
is-
a number of
who
anybody.
is it?
Yes.
Okay,
Okay, do you want the number?
yes, please.
Okay, wait. Can you get it and put it in my back pocket? Sorry. Sorry.
Oh, that's putting Mr. Romero in an awkward position, yes.
I'm sorry.
That's okay.
It's It's Lori McPherson. I'm so sorry, but it's the little one. I apologize. Oh my God, sorry. Thank you so much. Okay, it's Lori McPherson.
Yes.
It's 732 794 9310. And then if you can't get a hold of her, I can give you somebody else who will tell you the name.
Okay.
Antoine Daniels. 732 912 3503.
All right, I will put you on for the afternoon docket. It starts at 1:30. Hopefully you'll have counsel there at that time. If not, we'll revisit the issue.
Thank you very much.
Thank you. I'll put that. Daniela Rodriguez?
Ms. Rodriguez? She's approaching. She's here at me.
That'll be for the afternoon, yeah. Good morning, Ms. Rodriguez. You're here today accused of leaving the scene of the accident and a parole violation. The court does find probable cause for leaving the scene, and you'll be held no bond on the parole violation. State any objection to the bond?
No, Judge.
$100 bond on count one. Good luck to you.
Thank you.
Dolores Waynisha Pearson?
Ms. Pearson is here present at me. Come on up, ma'am.
Good morning, Ms. Pearson. You're accused of petty theft, giving a false ID to a law enforcement officer, possession of cannabis less than 20 grams, possession of ecstasy, possession of PVP, resisting an officer without violence, tampering with or fabricating physical evidence, and you also have a capias on a misdemeanor where bond is set in the amount of $250. The court finds probable cause on all counts except the cannabis, because I didn't see a field test on the cannabis.
Yes, I was going to make that argument in that regard, Judge. I didn't see a field test on
I didn't see
any
a
of them,
field test on
actually.
the other two. Well, actually, you're right. So I didn't see a field test on the MDNA for the ecstasy. The PVP, I can't tell which one's the pill. I think the pill, the officer may be able to, on his training experience, slide on.
I think he needs to call poison control.
Okay.
Well, I don't think he's limited to poison control, but there are other means, but they're not mentioned here. So I'm
Okay.
just going to ask
Right.
for
So
24 hours on the drug charges. Your
okay,
Honor.
so on 3, 4, and 5, the 24 hours, no PC, 24 hours to perfect. And then on the petty theft, the false ID, the resisting, and the tampering, what say you state?
I'm fine with the standard bonds as they are, Your
All
Honor.
right, what say you, defense?
Judge, I know, Your Honor, at this point, I believe you didn't find probable cause for 3, 4, and 5.
Correct.
She intends on contacting her brother to help post her bond, but her brother works in construction, so his financial resources are limited. I just asked you to entertain on counts 4 and 5, the court not having found probable cause at this time. Would you consider lowering her bond on counts 4 and 5 at this time to $500 each count?
No. How about, do you have any comments on the other ones, or are you satisfied with them as recommended?
No, well, then I would ask you, as far as on the misdemeanors on counts 1, 2, 6, 1, 2, and 6, considering, I believe that would even help out his brother speaking to a bondsman, would consider an R1 on counts 1, 2, and 6 then?
Your Honor, considering that she's also, based on the capias, missed 3 separate court dates on 3 separate cases, I just ask that the bonds be left as they are.
Judge, she's working at a gas station at Wawa. She just obtained the employment. She's been working about 3 months, making about $12 an hour. Besides that, she is going to Miami-Dade College. She's studying mortuary science, so she's receiving financial aid. She has a lot of things going for her. She's trying to better herself, Judge. That's why she's going to try and contact her brother. We're not asking for pretrial. We're not asking for RWAR across the board. We do realize the K pieces, and that's why we were asking if you could just help us out a little bit as far as RWAR certain counts, so that would assist her brother in posting bond with the bond.
I'm being advised she has an active warrant out of Dade County also.
Yeah, in addition to the prior county KPS is for failure to appear, she has a KPS for Dade County pickup only that was issued back in January of this year for driving with a suspended license.
Okay.
And the bond on that KPS is $1,000.
All right, based on our history and her failure to appear previously at bond set at $1,000, the court is going to set bond in the amount of $25 on the petty theft, $100 on the false ID, $100 on the resisting without, and $1,000 on the tampering. And we'll see her tomorrow for counts 3, 4, and 5, and see if we have an answer on those. Good luck to you, ma'am. Mary Shaban Mayer.
North Broward, Your Honor.
I'm sorry, I think it's Mara, right? Mara? Good morning. You're here today accused of possession of heroin, possession of cocaine, possession of drug paraphernalia, and violation of a municipal ordinance. Do you understand, for loitering for the purposes of prostitution? Do you understand what you've been accused of? The court finds probable cause on counts 1, 3, and 4. Possession of cocaine, counsel? I'm not quite sure I saw any cocaine.
No, it wasn't, Your Honor.
Okay.
Oh, wait.
I just see.
Yes, if you go to the last page,
Okay.
the second paragraph, last sentence.
A field-tested clear glass cylindrical crack pipe which yielded positives for this. I think that's what you needed for the possession of cannabis. I mean, for the possession of the drug paraphernalia. I don't know that doesn't. So.
Well, Your Honor, if it tests that there is cocaine present, then.
Okay. If there, it doesn't say. I don't know whether it's just residue or whether there's actual cocaine present.
Well, Your Honor, I would say even legally someone can be charged with residue. I think for probable cause, that there is probable cause. Certainly I could understand the court taking that in consideration for bond.
Okay.
But if it's there, it's there.
Well, I would feel more comfortable if it actually says there was cocaine in the pipe as opposed to I just swabbed it and it was positive for it. But, you know, that's fine. The court will find probable cause because of the residue, but I'm RORing her on that count.
Okay. Your Honor, to advise the court, Ms. Meyer is currently out on release. She was ROR'd on a filed possession of cocaine.
All right. So on count 1, what's your recommendation, if any?
Your Honor, I'd ask for a $2,000 bond on count 1.
How much?
$2,000.
Okay. Defense, anything you have to say regarding?
Wait,
Well, Ms. Meyer hasn't given me much to work with, and she's walking away from the podium,
that
so I
sounds
really don't
fine.
have much to add.
All right. Well, court's going to set bond in the amount of $2,500 on count 1. She's going to RR on count 1 and 2. And leave 4 at $300. Count 2 and 3 are RR. Count 1 is $2,500, and count 4 is $300. Thank you. Oh, thanks. Joanne Marie Evans.
That's North Broward again.
Good morning, Miss Evans.
Good morning.
You're here today accused of grand theft. Between the amounts of $300,000 and $5,000, the court finds probable cause. State, what say you?
I just need one moment, Your Honor.
Thank you, bud.
I'm sorry? What?
I just need one moment, Your Honor.
Okay, thank you.
Okay. Your Honor, I'm going to be asking for a bond in the amount of $2,500. Ms. Evans was convicted of theft July this year. She has 2 open petty thefts out of North Satellite.
Are those notices to appear? Did she actually have a bond?
No, actually, one moment, Your Honor. No, on one of them, she was arrested last week and bonded out on $1,000. She failed to appear and posted a $1,000 bond, was released last Wednesday.
And what case number is that?
That is on case number 17. Actually, it's on both cases.
Okay.
One is 17-1369 MM20A. Do you want the other case number? 17-1137 MM20A.
Okay. Defense, what say you?
Judge, I'd ask you not to address the bonds on the other 2 outstanding charges. Miss Evans has been living here in South Florida for 5 years. She has a lot of friends here in the area. She works repairing pool tables. She's had the same job for the last 2 years. She's been living in the same location where she lives now for the last 3 years. She's provided me with the number of her boyfriend, who she's hoping will be able to bond her out. But she believes that $1,000 is probably toward the high end of what he's going to be able to afford to post for her. So I'd ask the court to consider a $1,000 bond or leave the bond where it is at $1,000 for Miss Evans.
All right, I'm sympathetic to your argument, counsel, but the fact that she's already escalating her behavior from petty theft to grand theft and has already been given release and is unable to refrain from allegedly violating the law on conditions of release, the court does not find that there are conditions at this point that will protect the community from her repeated violations of the law and is revoking her pretrial release on case number 17-1369-MM28, 17-1137-MM28, holding her no bond on those cases, setting bond on the grand theft in the amount of $5,000. PC is found.
And I'll call Mike for you.
Peter Allen Haas.
Mr. Haas is here, present judge at Maine. He's respectfully asking Your Honor if you would consider resolving this case today.
Mr. Haas, you're here today on 2 misdemeanors, one having for unlawful license tag or sticker attached and failure to register that vehicle. Bond is the amount of $350 on both cases. Let me look your written. Let me see. Haas. What I can do, Mr. Haas, do you own that vehicle that was unregistered?
No, the vehicle was no good. It ended up getting junked.
Okay, so it's no longer in service?
No longer in service.
All right, I'm willing to do it. Raise your right hand. Do you swear to tell the truth, the whole truth, and nothing but the truth?
Yes, Your Honor.
Put your hand down. Tell me your name.
Peter Haas,
How old are you?
28.
Are you under the influence of any drugs, medication, or alcohol that would affect the way you're thinking today?
No, ma'am.
Have anyone threatened you or forced you to take care of this case today?
No, ma'am.
Have you ever been treated for a mental illness?
No, ma'am.
Are you understanding what you're charged with and what the proceeding today is?
Yes, ma'am.
Do you wish to give up your right to have an attorney represent you and go to trial on these charges?
Yes, ma'am.
You understand that both of these are second-degree misdemeanors that are criminal offenses and will go on your record even though you'll have a conviction for them today?
Yes, ma'am.
All right, do you plead guilty or no contest?
No contest.
Court accepts your plea of no contest. I do find there's a factual basis. Based on review of the traffic citation and your driving record, I find that you freely, voluntarily, intelligently waived your rights, that you only entered this plea without the advice of an attorney, that you only waived your right to an attorney in trial, and accordingly I sentence you to an adjudication, time served on both counts. Good luck to you. Court costs will be $293. Can you afford to pay within 90 days? Or do you need more time?
I need a little bit more time.
I'll give you 6 months. Good luck to you, sir. Alexander Arnold?
Mr. Arnold, come on up, please. He's here, approaching judge at Maine.
Mr. Arnold, you're here today accused of violations of probation for 2 cases, and you'll be held no bond for violations of probation. You'll have to see your judge. Good luck to you, sir. Which one is this? Oh, it's on recall. Roberto Alexander Gonzalez. Hola. Mr. Gonzalez, you're here today for a violation of probation for a misdemeanor. You're going to be held no bond until you see your judge. I wish you the best of luck. De nada. Seth Potter.
Mr. Potter's approaching judge of the municipal ordinance case.
Mr. Potter.
Good morning, Your Honor.
Good morning, sir. You're here today on a misdemeanor. KPS is for alcoholic beverage violation and solicitation on public property. Bond is set in the amount of $50 on each case. Do you understand?
I do, Your Honor.
Can you afford to post that bond?
No, I can't, Your Honor.
Would you like to resolve? Would you like to resolve this today?
That would be wonderful.
Raise your right hand. Do you swear to tell the truth, the whole truth, and nothing but the truth?
I do.
Put your hand down. Tell me your name.
Seth Potter.
Is anyone forcing you to take care of these cases today, Mr. Potter?
I'm sorry?
Is anyone forcing you to take care of these cases today?
No, Your Honor.
Are you under the influence of any drugs or alcohol that would affect your ability to make a decision regarding your case today?
No, ma'am.
Have you ever been treated for a mental illness?
No, ma'am.
You're here today for the 2 charges that I indicated. Do you understand them?
I do.
And do you wish to accept the court's offer of an adjudication time served? You would be giving up your right to a trial and your right to have an attorney represent you at that trial.
I do.
Do you plead guilty or no contest?
No contest.
Court accepts your plea on both charges. The court finds that you freely, voluntarily, and intelligently waived your rights for an attorney and for a trial, and accordingly sentences you to an adjudication and time served. Court costs are in the amount of, $78. Can you afford to pay?
Not at this time. If you could give me a little more time, that'd be wonderful.
Do you need 90 days or more time?
If you could do 6 months, that'd be fabulous.
6 months to pay, 30 days to appeal. Good luck to you, sir.
Thank you very much.
You're very welcome. Patrick John Lyman.
Mr. Lyman is approaching, Judge.
Mr. Lyman, you're here accused of disorderly conduct, brawling, fighting in the public, resisting an officer without violence, and trespassing an occupied structure or conveyance. Do you understand the charges that you're accused of?
Yes.
State, what say you?
Your Honor, I'm just asking that the convenience bonds be kept in place.
All right, so on the resisting, it's recommended $100. Defense, what say you?
Judge, he's fine with it. He's going to contact his friend. The only thing we'd be asking for is a phone order so he can get the phone number of his friend.
All right, $100 on count 1, ROR on counts 1 and 3. And do you want this located? This happened at the airports. I guess I can't get away from there. All right, sir. Good luck to you. It's on 2. Peter Rydell.
North Broward, Your Honor.
Thank you.
Mr. Rydell would like to resolve this matter if possible, Judge.
Mr. Rydell, you're here today on 2 misdemeanors, 1 for resisting obstruction without violence and defrauding an innkeeper. I'm not inclined to resolve the defrauding an innkeeper without input from the innkeeper, so let's deal with bond. What say you? Is this a state case?
Yes, Your Honor.
Okay.
I'm just checking to see if there are other prior failures to appear. I don't see any other prior failures to appear.
Does he have a residence, or is he?
That's.
Do you have a place you stay at, sir?
Yes, me and my wife live at 1901 Ocean Drive in Hollywood.
Okay. How do you feel about pretrial release? Would that be something you'd be interested in?
Yes, ma'am. I'd like to resolve it today. I had no intention of missing this court date. I moved and I didn't get the
Peter,
court date.
don't say anything else. We're not going to be able to resolve the case this morning, but the judge is willing to let you out of jail without having to post a bond if you're willing to comply with the conditions of pretrial release.
Yes, sir.
Did he say 1901?
What address was that again, sir?
1901 North Ocean Drive,
Okay.
Hollywood, Florida.
Is that the location?
Yes.
That's just weird. No, it's just weird. I guess they have it wrong on the permanent address on his booking because it says 1908.
Oh, okay.
And-
you might have to clarify that.
And is there an apartment? Because I see that there was an arrest in an apartment. So is it an apartment
Is
or
there
a
an
home?
apartment number, sir, or is that a home?
Apartment number 1, ma'am.
Apartment number 1. Can we indicate to correct his address on the clerk's system to 1901, apartment number 8? And the court's going
Apartment
to.
one.
I'm sorry, apartment number 1. Thank you for clarifying. And the court's going to order pretrial release on counts 1 and 2. And good luck to you, sir.
Thank you, ma'am.
Upon verification of address. Thank you.
Yes, ma'am.
Luke Matthew Carmichael.
Is the med reset, Your Honor?
Okay, thank you. Kenny Lewis Moreno Vega.
North Broward. Get back inside self-rip.
Good morning, sir. You're here today accused of distributing or delivering cocaine. The court does find probable cause. State.
Your Honor, just check. Okay.
It's an ad charge. It says.
Yeah, yes, Judge. He's being held on $25,000 on other charges. He's got a no bond hold on a robbery firearm, so I'm just going to ask that this bond be kept in place. I'm not asking for an increase.
All right. Defense, anything to add? Or
No, Your Honor.
$2,500 on count 7 as an ad charge. Good luck to you, sir. Roy Lee Addison.
Conti.
Good morning, Mr. Addison. You're here today accused of burglary of an occupied dwelling. The court finds probable cause. This is also an ad charge. I guess this was the 4th one?
Your Honor, he's being held right now for grand theft auto, $1,000 bond, grand theft, $1,000 bond, fraud, uttering a forged instrument, $1,000 bond, and a capias on uttering a forged instrument, $1,000 bond.
Okay.
Based on the allegations that this was someone's home, Your Honor, I'm going to be asking for a $10,000 bond.
This was an empty home, but.
Well, no, it wasn't. No, it was just a part-time resident, Your Honor.
Right.
It wasn't like it was an abandoned home.
No. What I'm saying is this is like a winter home, correct? That was empty.
Yeah, no. If it was occupied, frankly, I'd be asking for
Okay.
a much higher bond.
All right. What say you?
Judge, I did not get a chance to talk to Mr. Addison from Conte. Unfortunately, we weren't able to get a call back before you took the bench, so I didn't get any information on his ties to the community. I know he has not been able to bond out on a $4,000 bond, so I imagine a $10,000 bond is going to be well beyond his reach. Is that correct, Mr. Addison?
Yes, sir, that's
Is
correct.
there anybody
Does that
going to
have
be
any
able to
priors?
bond you out?
One moment, Judge.
I'd ask for a $2,500 bond, Judge.
In light of his
Oh, I was just if you want to know, I was checking to see what his history is.
Yes.
Okay, 2014, grand theft firearm, false imprisonment, tampering with a witness or victim, and battery. 2013, strong arm robbery.
Okay, I've heard enough. Bond is in the amount of $15,000 on count one. Good luck to you, sir.
Don't discuss your case with anyone, with Mr. Addison.
Yes, sir.
Sean Shurikens Darabal.
Conti.
And
How you doing, Your Honor?
Good morning, sir. You're here today accused of burglary of an unoccupied structure.
Yeah.
And you have 8 capiases on felony charge of 17008707 CF10A.
Your Honor, if I could,
Is this
I'll
an
wait.
additional ad charge?
Count 4 is a change of charge.
Okay.
The remaining counts are add charges. If the court finds probable cause, I could either, if you like, I could proffer what the allegations are. I could print out a report.
You can go ahead.
Okay, Your
Your
Honor,
Honor, I'd like to just advise the court initially that our office, the Office of the Public Defender, has withdrawn from representing Mr. Derival as we currently represent his co-defendant in the same
Okay,
case.
so then before we proceed, counsel, let me talk to Mr. Derival. You are entitled to have an attorney represent you at this hearing, especially in light of the fact that the state is indicating that they've added numerous additional charges to your situation. At this time, the Public Defender's Office is unable to represent you. Are you going to be hiring an attorney to represent you, or do you need court-appointed counsel?
I got to check, cause my people got a family lawyer, but I don't know yet.
Okay. Would you like me to reset this for the afternoon to try to get a hold of an attorney to represent you at this hearing? Or would you like me to appoint an attorney to represent you at this hearing?
You go point of change.
Okay, I'm gonna have to reset you to the afternoon so I can get a private attorney to, or regional, does Regional Conflict Counsel?
They're still on, technically, just, motion was filed, but it wasn't ruled on yet.
Hold on a sec. Gentlemen, do we go to Regional Conflict Counsel in these situations?
Well, Your Honor, if I could just have one moment.
Okay.
Brian, I'm looking at Odyssey, and I see that the motion was filed, but I don't see anything granting it. Well, I know we've had motions to release where you guys have filed motions that hadn't been ruled on, but
Talking about adding on charges.
I understand, but I'm just saying.
All right,
of
at this point, Mr. Derival, I'm gonna put you on for the afternoon's docket while I try to get you representation.
I know.
Yes, ma'am.
I'll see you this afternoon.
Yes, ma'am.
I need stickies, all right, remind me that I have to reset this for the afternoon. Can someone contact Regional Conflict Counsel, let them know they need to be here in the afternoon? I'm assuming they're the go-to when the PD has a conflict.
Yes, Judge.
Thank you.
I show our office is still on the case.
All right, well, between now and then, you want to
but
file appropriate
It looks as though we do have a
motion to withdraw filed?
motion to withdraw.
All right, well, it's on for the afternoon. Talk to the powers that be in your office and see how they want to handle the first appearance hearing. But it sounds like there's a conflict.
It does to me. All right, very good, Judge.
Dante Lang.
All Ryan, good morning.
I'm not getting a hold of anything. I'm just saying.
All Ryan, man.
Thank you. Good morning, Mr. Lang. You're here today on an ad charge for a capious on felony 17008644 CF10A that was added for lewd or lascivious molestation. The court does find probable cause.
Your Honor, and I provided both the court and Mr. Reedy with paperwork on this case. Really, the only additional information for this count is an allegation of a third instance, relying upon the allegations from his original first appearance on the original two charges. Your Honor, I'm going to be requesting, I'm going to argue that this is a punishable by life offense based on the age of the alleged victim, arguing that there, for first appearance purposes only, under Isaza v. State, that there is proof evident or presumption great, and ask that Mr. Lang be held no bond.
Defense?
In light of the fact that Mr. Lang is already being held no bond, we would reserve any issue related to proof evident presumption great until a later time. Our office does represent Mr. Lang. His attorney is Vivian Garibaldi. I will let her know that Mr. Lang was in court this morning.
All right, well, the court has reviewed the affidavit for arrest. The court does find probable cause for the ad charge, and I find that there is proof of guilt to be evident or the presumption great, and therefore you will be held no bond until further order of the court on this additional ad charge. However, this order is without prejudice for you to file any motion to set bond with your assigned division judge and request a hearing under State v. Arthur. Good luck to you, sir.
All right.
Jay Blongi?
Yes, Your Honor. Good morning.
He's here, present, Judge at Maine.
Thank you. I'm not sure if I said that correctly or not. If I didn't, apologize.
Yes.
You're here today, sir, with an additional charge also that was filed to you for a capious for aggravated battery with a deadly weapon. The court does find probable cause.
Your Honor, the state is going to be requesting a $100,000 bond and no victim contact. Your Honor may recall, Mr. Blongi, you actually, when I believe you were here on a weekend, and you had a change of charge for manslaughter. And
Oh, that's correct.
you set his bond at $250,000 pretrial release with the level 1 GPS monitor. He's also being held no bond on a capious for possession of amphetamine. I would also note the allegations in his manslaughter is that he used a knife and stabbed the alleged victim, Your Honor, noting that the allegations in this case also involve him stabbing his brother with a knife.
Defense?
Judge, and speaking of Mr. Blanche, I believe he's been in custody now for about 2 months. He has no money. He's being held no bond. Judge, I'd ask you to take his financial resources into consideration in determining a reasonable bond on Mr. Blanche's behalf.
Do we have any information from the victim in this case?
No, Your Honor, but I can tell you it's a file felony, which indicates to me a sworn statement was taken from the alleged victim. I do remember reading this probable cause affidavit when his manslaughter came through the first time as a murder case, and it did concern me that it was basically the same MO as in both victims. He allegedly, stabbing both victims.
All right. Based on the nature and circumstance of the offense, his criminal history, the weight of the evidence that appears in this report, and the court's going to set bond in the amount of $50,000. Good luck to you, sir.
That's for an order of no victim contact, Your
No
Honor.
contact with the victim in this case, no direct or indirect contact with the victim in this case. You must stay at least 500 feet away from his home, place of work, or school. You must surrender any weapons, including any knives in your possession, to law enforcement, including firearms and any weapons permit that you have, and provide proof of same to the clerk of court.
And Your Honor, the only other thing I would ask for,
He doesn't reside at that home, does he? Or?
I frankly don't know, but
Okay.
the only other thing I would ask you, since you placed him on pretrial release with a GPS on his manslaughter, I'd ask that he have that also in this case.
Additionally, if you do post the bond in the amount of $50,000, the court's going to order GPS monitoring.
I believe you ordered level 1 on the manslaughter.
Level 1. Thank you.
Anything else, Mr. Lender?
That's it. Thank you. Sorry, I read the PC on the previous one. Stanley
Just
Martin.
remember that question goes both
Paul
ways.
All right, ma'am.
Good morning, Mr. Martin. You're here today because you have two add charges on a KPS felony on case number 17009136 CF10A for the charge of human trafficking for sex activity, 2 counts. The court does find probable cause on both counts.
And again, Your Honor, these are punishable by life offenses, and I've provided the court with both the probable cause affidavit for these charges and the initial arrest warrant affidavit for the charges that are linked to or led to these charges being presented and filed. Your Honor, under Isaza v. State, I would argue that there is proof evident or presumption great for first appearance purposes only, and ask that Mr. Martin be held no bond with an order of no victim contact.
Defense?
Your Honor, Mr. Martin is currently being held no bond on other counts in any event, so we will
Defer to the court.
we will defer to the court. We will reserve argument regarding bond for a future time. His attorney is Joe Lawrence from the Public Defender's Office. I'll let Mr. Lawrence know that Mr. Martin was here in court this morning.
All right. Mr. Martin, the court does find probable cause on both charges. I do find that there is proof of guilt to be evident or the presumption is great. Therefore, you'll be held no bond until further order of the court. However, this order is without prejudice to you to file a motion to set bond before your assigned division judge and to request a hearing under State v. Arthur. I wish you the best of luck. And your attorney is already aware of these charges, so he can deal with them as he sees fits. Good luck to you. Eric Donald Roberson.
Conti.
Mr. Roberson, good morning. You're here today accused of grand theft. It is an additional charge. I do find probable cause. State.
Your Honor, I'm just checking to see what count 1 is. He's being held on a grand theft on count 1, $3,500 bond, just requesting that the $1,000 bond be kept in place.
Defense, anything to add?
That's fine, Judge. He's currently, as the state says, being held on a $3,500 bond. His attorney is Richard Eagle. I'll let Mr. Eagle from the Public Defender's Office know to deal with Mr. Roberson's bond issues in front of his division judge.
All right, at this time, the court's going to find probable cause set bond in the amount of $1,000. Good luck to you, sir. Kevon Mowat.
Judge, I've been advised, I guess he was removed from the docket per confinement status?
I don't know what that means.
I have no idea what that means.
I'm sorry?
Okay, so.
Yes. For PM, for the afternoon? Okay, thank you. All right, we're going to put them on, for some reason, they have them on for the afternoon.
Gotcha.
All right, so. Good morning.
Our Spanish interpreter is present, Your Honor.
Yeah. Do we have any Spanish cases?
On page 15, we have, I believe it's Mr. Silvera.
Mr. Silvera, ven aquí, por favor.
Where's his case? Good first name.
Okay, Mr. Silvera, good morning. You're here today for a violation, oh, sorry, before I begin, raise your right hand. Do you swear to translate from English to Spanish and Spanish to English to the best of your ability?
I do.
Thank you. All right, Mr. Silvera, you're here today for a violation of probation.
Señor Silveira, usted está aquí esta mañana, buenos días, por haber quebrantado su libertad probatoria.
The recommendation is to be held no bond, so you'll have to be in custody until you see your assigned judge.
Le recomiendan que la fianza, que no le presten que no le pongan fianza, por lo tanto tendrá que esperarse dentro de la cárcel hasta tal momento que usted pueda ver su juez principal.
Does he have a date?
¿Ya tiene el fecha?
September what? 9th. September 9th at 9 o'clock.
Sí, el 9 de septiembre a las 9 de la mañana.
Good luck to you, sir.
Buena suerte, señor.
Anybody else?
Let me, ¿alguien más habla solamente español? ¿Tú? ¿Qué es tu nombre?
Carlos Jelby.
Carlos? Jelby. Judge, we have Carlos Jelby.
Okay.
I don't know what page. Let me try and locate
That's
it.
okay. I'm looking through the names.
Oh, he's 2 in front of Mr. or 3 in front of Mr. Silvera. or behind.
I got it, Carlos Yelpy. All right, come. Mr. Yelpy, you're also here for a violation of probation. The recommendation is that you be held no bond until you see your assigned judge.
Señor Yelpi, usted tiene también, lo tienen aquí por haber quebrantado su libertad probatoria. La recomendación es que le tengan dentro de cárcel sin fianza hasta tal momento que usted pueda ver su juez principal.
Your next court date is going to be August 31st at 10 a.m.
El 31 de agosto a las 10 de la mañana es su próxima fecha al tribunal.
Oh, I'm sorry. It's a misdemeanor, so it's not a felony.
Disculpe, es un delito menor, así que no es un delito grave.
It was a violation on the charge of driving under the influence.
Es haber quebrantado por un cargo de conducir bajo los efectos.
And you'll see Judge Brown.
Usted se presentará frente al juez Brown.
Good luck to you.
Buena suerte.
Fine. Anybody else?
¿Alguna otra persona?
No one else that main judge.
Let me go try right.
Thank you, Judge.
Hold on, don't leave. Is there anybody that speaks Spanish at Paul Ryan? Hearing none. Is there anybody that speaks Spanish at Conti?
No, ma'am.
Thank you. Is there anybody that needs a Spanish interpreter at North Broward?
No, Your Honor.
All right, thank you very much. Thank you, Mr. Interpreter.
Thank you, Your
You're
Honor.
excused. All right. William Taft.
He's here approaching Judge at Main, Your Honor.
Mr. Taft, good morning. You're here today accused of possession of Xanax, possession of cannabis less than 20 grams, and you have 2 capiases, one for a felony, which will be held no bond, and one for a misdemeanor where bond is recommended to be $100. What say you state regarding the Xanax?
Your Honor, I'm not asking for any modification.
Defense, anything to add?
Judge, he's being held no bond.
All right. Bond in the amount of $1,000 on count 1, $100 on count 4, ROR on count 2, and no bond on count 3. Giovanni Kelsey Vega.
Mr. Vega's approaching Judge. He's here at Main.
Mr. Vega, you're accused of burglary of an occupied conveyance, grand theft, resisting an officer without violence, probation violation, where you're recommended to be held no bond, and you also have an out-of-county hold for a felony that you're being held no bond. Any objection to the recommended bond defense on count 2 and 3?
Excuse me, again, count 3.
Is not a felony?
Well, it's a misdemeanor, but it's obstruct, disguised person, not, I think they go to resist. It was the wrong
They didn't put that on the thing. Let me see. Okay. Can add that to this sheet. All right, let's start with defense. Any objection to the $1,000 bond?
For one? No.
For count 2.
Yes, he has it. Oh. Judge, he has a probation hold.
Right. All right. State, what are you recommending on count 1?
Your Honor, based on what he is currently on probation for at Dade County, I'd be requesting a $7,500 bond on count 1.
All right. What's the Dade County? Same thing?
Grand theft auto, assault, fleeing and eluding law enforcement.
Okay. Defense, anything to add?
Judge, he's not working at this time. He has no sort of money, no sort of money in the bank, no property.
All right.
He's financially indigent.
All right. Well, the fact that he's going to be held no bond, the court's setting bond in the amount of $7,500 on count 1, $1,000 on count 2, and $100 on count 3. Good luck to you, sir. Stanley, $7,500. Stanley Mueller?
Come on up.
Mr. Mueller, you have violation of probation on case number 11-5565 CF10A and also 11-18783 CF10A. Both of them are for no bond holds. You'll have to see your assigned judge. Good luck to you, sir.
You're going to see your judge August 31st at 8:30. Good luck.
Michael Kazaja? Good morning, sir. How do you pronounce your last name? Seja. Sorry. You're here today, sir, because you have a misdemeanor capias for case number 16-2819-4TC-48 and 2 violation of probation warrants where you'll be held no bond. You have a status set for September 5th on the violations and a status on the capias on August 31st. Bond is recommended to be $1,500 on the capias for the misdemeanor. Wow, okay. Anything that anybody wants to add?
No, Judge.
All right, thank you.
Good luck, sir. Thank you.
Austin Osborne. Good morning, Mr. Osborne.
Define the services of public defender.
Okay, Mr. Osborne, you have a right to have an attorney represent you. Are you going to be hiring a private attorney to represent you, or do you wish to proceed without representation at this time?
I already have a private attorney.
Do you want me to reset this hearing for your private attorney to be present, or do you want to proceed at this time for me to tell you while you're in custody?
No, it should be all right by myself.
Okay, the court finds that you're waiving your right to have an attorney present at this hearing. I'm informing you that you have a violation of probation warrant where you'll be held no bond until you see your assigned judge. Your next court date is September 1st at 9 a.m. Let your attorney know, okay? Good luck to you. Roberto Diaz.
North Broward, Your Honor.
Mr. Diaz, you're here today accused of grand theft. You also have 3 KPS felonies for possession of cocaine and tampering with physical evidence and grand theft. You'll be held no bond on the KPSs. Court does find probable cause on the grand theft. Does anybody have anything to add on the grand theft? And defense? No?
No, Your Honor. Ms.
Okay.
Freitas is his attorney from our office. I'll let her know that he was here this morning.
All right, bond in the amount of $1,000 on count 1. Good luck to you, sir. Eric Michael Hayes. Good morning, Mr. Hayes. You're here today on 2 violations of probation, 1 for a misdemeanor and 1 for a felony. Both you'll be held no bond. You have a status on September 5th on the felony and a status on September 11th at 2 p.m. on the misdemeanor. Good luck to you, sir. Simeon McGregor.
With the eyes. What's that?
I'm sorry, where?
Well, that's the squinty part.
I'm sorry, McGinson. I misspoke.
Meganson? Seaman Meganson on page 16? Oh, it's a reset. Judge, I'm going to advise this medical reset.
All right, medical reset till tomorrow. Breon Henry.
Mr. Henry, come on up, please.
Good morning, Mr. Henry. You're here today accused of driving while your license is suspended with knowledge. The court finds probable cause. You also have a violation of probation where you'll be held no bond till you see your assigned judge. Any objection to $100 bond on count 1?
No.
So ordered. Thank you. Okay, David Lane.
Mr. Lane, come on up, please.
Mr. Lane, you're here today accused of robbery with a firearm. The court does, it's based on, why is this says no bond?
Your Honor, robbery firearm is a punishable by life offense. Okay. The state is going to be seeking a no bond upon a finding of proof evident or presumption grade for first appearance purposes only under ESASA v. State. Your Honor, and under the theory of Mr. Lane acting as a principal, Your Honor, the allegations satisfy, or the elements of the offense, noting on the arrest warrant affidavit that the entire crime was captured on store surveillance, and that Mr. Lane was identified by Detective Cade, who authored the arrest affidavit, who is familiar from previous encounters with Mr. Lane, noting that his most recent previous encounter was only 2 weeks prior to this alleged incident.
Defense?
Your Honor, the state is asking the court to impose the most restrictive means of pretrial detention, which is a no bond hold. They have to establish that proof is evident and the presumption of guilt is great. In order to establish that, all they've introduced today is an arrest warrant. They haven't called any witnesses. They haven't produced any physical evidence. This is insufficient to reach a standard of proof that is even higher than proof beyond and to the exclusion of each and every reasonable doubt. Before this court can find that proof is evident and presumption great, this court needs more than just a printed document to reach that conclusion. Even though ESASA v. State says that the court can do it based on a probable cause affidavit, it doesn't say that it has to, and the evidence presented in this affidavit or this warrant is insufficient to reach that standard.
Your Honor.
What is his history, Benny? Are you here for court, sir?
Yes.
You are on behalf of a defendant?
I'm the defendant.
Oh,
He might be for next door, maybe.
You may be in the wrong courtroom. We'll assist you in a moment.
Okay. One moment, Your Honor.
No problem.
Okay. Well, first off, I'm showing that Mr. Lane is currently on probation.
I object to that argument. It's completely irrelevant as to whether or not there's proof evident or presumption great.
I'm answering.
No, it's an irrelevant argument as to whether proof is evident or presumption is great in this case.
Absolutely, counsel. The court does find that proof is evident and presumption great. I was trying to consider whether or not I wish to hold him pro bond. Based
Okay.
on
In that
his
case, it
record.
is relevant.
You know,
Just answering the judge's question.
because I don't know what his history is, but I just to make the record clear, the fact that the allegations in the police report indicate that he pointed a handgun
And Your Honor, I'm sorry.
at the victim, placing him in fear while demanding money, and that it was on store surveillance system. Based on the affidavit, the court does find that proof is evident, presumption
And I'm sorry,
great.
Your Honor, his co-defendant is the one that pointed the gun.
Oh,
He
okay.
allegedly went into
Yes.
the victim's pocket taking the money.
Correct, but
I
he was with
apologize.
him when they
Yes.
came back, so it's based on the fact that they were together.
Your Honor, his additional priors, 2010, burglary of a dwelling, possession of firearm by a felon, carrying concealed felon, 3-year state prison. 06, robbery with a firearm or deadly weapon.
06?
Yes.
Okay. What else do we know about Mr. Lane, other?
Judge, as far as his ties to the community, and speaking with Mr. Lane, he's 30 years old, been residing in South Florida his whole entire life. He did attend Ely High School. Unfortunately, he didn't graduate. However, he did obtain his GED. At this time, he's currently unemployed. He's looking for employment at this time.
Okay.
He lives with his family in Pompano Beach. He's been basically living in Pompano Beach his whole entire life.
Do you know if his family owns a home?
No, they're renting the apartment. They've been renting that apartment for now about 3 months. The only person he says that he can contact to help post his bond is his girlfriend. His girlfriend works at an office. She's like kind of like the office secretary / clerk. I try to inquire about how much she gets paid. He doesn't really know how much she gets paid. He owns no property.
All right, I don't know that he's gonna be able, but
Your
what's
Honor,
he on probation for?
He's on probation for domestic violence battery, Your Honor. Noting that he's on probation for a violent offense, I do not believe that there are any release conditions. Considering he's now alleged for participating in a violent offense, I do not believe that there are any release conditions
Did
that
we
can ensure the
address the
safety.
probation case that he is on?
Your Honor can, if you so choose, under
I would
Florida
like
Statute
to.
94806, if the court has reason to believe,
What is the case number on that case?
it is 1610410 MM10A.
Court is going to revoke his bond on case number 1610410 MM10A for pursuant to 948.06. The court finds that there, in this particular situation, there are no reasonable methods to protect the community from his ongoing criminal activity, especially in the escalation of the violence. He was on probation for allegedly a violent act for domestic violence, and while on probation, the supervision of the court, he's alleged to be a co-participant in an armed robbery that occurred on August 13, 2017, where he and another defendant did commit a robbery where the co-defendant was armed with a handgun, putting the victim in fear. This incident was captured by store surveillance, so the court does find that the proof of guilt to be evident and that the presumption is great that there will be a conviction in this case, and as such, the court is going to hold him no bond on the new case as well.
Yeah, one, I would just ask for no victim contact, and two, just in case there's a review of this record, Your Honor, the court's ordering him to be held for violation of probation under 94806.
Correct.
Okay.
And there will be no, I guess, in this particular instance, no indirect contact with the victim in this case. He's in custody. I don't know how he should.
My only concern, Your Honor, and I'm not saying it would happen here, but we have had cases
Where it's
where
weird.
phone calls have been made, letters have been sent, so it's just an abundance of caution.
So there'll be no direct or indirect contact with the victim in this case in any means whatsoever. Good luck. All right, thank you.
Judge, just
Yes.
for clarification regarding Mr. Lane, this hearing that we had, which was non-adversarial in nature, I just want to make sure it
Absolutely.
doesn't prevent Mr. Lane's attorney to go ahead and arguing and having a full Arthur hearing where court would have to make both findings, proof evident presumption great, and then can consider whether or not to use their discretion. I just want to clarify that.
And for the record, this is based solely on the warrant or arrest that's before this court that, and it is without prejudice for the defendant to seek a motion to set bond before his assigned judge and request a hearing under State v. Arthur.
And the state concedes that point as well.
Thank you. Did I already get that? Troy Allen Powers.
Mr. Powers, come on up.
Mr. Powers, you are here accused of burglary of an unoccupied structure, unarmed, petty theft, and another count of burglary and petty theft. State, I don't know that I have sufficient for 2 counts of burglary and petty theft.
Do you have 2 reports, Your Honor?
No, oh, that's why I only have the 1 report.
There might be the second report behind it.
Okay, oh, there it is. I didn't see it. There we go. Okay, then I do. I thought he was just making reference to the second one and the first one. So then the court does find probable cause for counts 1, 2, 3, and 4. What is your recommendation?
Your Honor, the state is seeking bonds on counts 1 and 3 at $5,000 apiece. Mr. Powers' criminal history, he had 2 resisting without violences in 2016 and 2015, grand theft auto and a violation of his pretrial release conditions. He violated probation, was sentenced to 16.5 months state prison, battery 2015, 3 thefts in 2014.
Defense.
Judge, in speaking Mr. Powers, he's 50 years old, been residing here his whole entire life. At this time, he's living in Hollywood in an efficiency. He's been residing in the same efficiency for about 4.5 years. He lives there with his girlfriend. Their monthly rent at the efficiency is $800. At this point, his girlfriend's the only one who's working. She's a waitress, so she's the sole financial provider of Mr. Powers. He's in the process now of applying through disability because of various mental health issues, unfortunately, Mr. Powers suffers from. So as far as financially, he has no money in the bank, no property. The only one he's going to contact is his girlfriend. Judge, I'd be asking you to consider setting a bond of $1,500 on count 1, $1,500 on count 2. That would make it a total about $3,000. That might be something his girlfriend may be able to afford.
Based on his criminal history, his inability to refrain from violating the law while under court supervision, and failure to appear, the court is going to set bond in the amount of $5,000 on count 1 and 3. I'll RR him on counts 2 and 4. And no return to the location of these thefts, which are, state?
Walkabout Beach Resort.
Walkabout Beach Resort.
Thank you, Judge.
Good luck to you, sir. Xavier Gaddy.
I believe that's a medical reset, Judge.
Okay, reset. Charles Thomas.
Mr. Thomas, come on up, please.
Mr. Thomas, you're accused of operating a vehicle without having a valid license. You also have a violation for a probation violation, where you'll be held no bond until you see your assigned judge. Your next court date is September 5th. Court finds probable cause on count 1, bond in the amount of $25. Any objection to that?
No, Judge.
Okay, so ordered. Alan Jesus Ura.
Judge, I've been advised he bonded.
Okay, court finds probable cause on count 1, 2, and 3. Bond in the amount of $1,000 on count 1, ROR on count 2 and 3. John Titus Palmer. Mr. Palmer? Where would Mr. Palmer be?
He's in North Broward, Judge.
Thank you.
He's a med reset, Your Honor.
Okay, thank you.
I was daydreaming for a minute.
No, that was me. I didn't even see you. My fault. Thank you. Curtis Grant.
Mr. Grant's here at Maine.
Thank you. All right, Mr. Grant, you're here today for a probation violation where you'll be held no bond. You also have a county hold where you'll be held no bond. Good luck to you. Julio Cesar Garmas.
Mr. Garmas is here present, Judge, at Maine.
Mr. Garmas, you're accused of grand theft. The court does find probable cause. State, what's your recommendation?
Your Honor, one moment. What? Oh, okay, I'm sorry. I believe pretrial has some information, Your Honor.
Yes, ma'am.
Mr. Garmas is currently on pretrial supervision in case number 1500053. 563 CF10A, felony battery with a prior. At this time, we are requesting a revocation of his supervision.
Defense, what say you, if anything?
Judge, I'd ask you at this time not to take any action on his case that he's currently out on pretrial, but however, if Your Honor doesn't choose to revoke his pretrial, I'd ask you to set a $1,000 bond on the case that he's currently out on. Also, Judge, I'd ask you to leave the standard bond in place on the grand theft. He's 41 years old. He is not working. He receives disability, $779 per month. He lives with his mother in a trailer park that they've been living at in Hallandale basically for 4 years. His mother receives disability, so therefore their financial resources are limited. So that's why I'd be asking you $1,000 on the case that he's out on, $1,000 on this case, Judge.
State, what's your recommendation on the felony battery for a bond?
Your Honor, I would ask that it be kept in no bond and let Judge McCarthy decide the best way to proceed if the court is inclined to revoke.
Do we know what the allegations of that original charge was?
I can see
Hold
if
on,
I
let me
can,
look it up. Give me a second. Computer goes dead very quickly.
yes, it's an odyssey. Yeah.
He has a case pending in front of Judge Porth, from what I'm showing.
No, it's not in Judge Porth anymore. It's in Judge McCarthy. That's the case that he's on pretrial for.
Change my lawyer. Judge, just to give you a little background, I believe the date of the offense is about 2 years old. He's been going to court. From what Mr. Garmas has been advising me, he hasn't missed court. I know he's been very curious about his case. He's been contacting his attorney, but unfortunately he's had several attorneys, but he still managed to come to court.
Is this case number correct? Oh, there it is.
I just wanted to share that with the court.
I appreciate that. The court is concerned that while out on pretrial release, he has picked up a new offense.
Show up to court apparently.
So was he living in the house? Obviously, it must have been someplace else. Okay. All right, the court's going to grant the pretrial revocation on case number 15000563 CF10A based on his finding probable cause for the grand theft for violating the law while on pretrial release, which is a violation of the pretrial release conditions. Based on the allegations, the court's going to set bond in the amount of $15,000.
So that's a $15,000 bond on the revocation of
Yes.
pretrial release on the 2000.
And then on this particular case, the court's going to set bond in the amount of $1,000. Good luck to you, sir. Oh, sorry. That goes back
On
to
the
pretrial.
case that he's out on, you said $15,000, correct?
On the revocation, yes.
Thank you.
Your Honor, the family on Miss Carballo is here.
Okay. Recall on Karina Carballo.
Lisa.
He's approaching, Judge.
Please step up to the podium. Thank you. Ms. Carballo, you're here today accused of burglary of an occupied conveyance, 2 counts, and grand theft. The court does find probable
I
cause.
don't know where it's held. I know Judge Bailey does it. I'm sorry.
That's okay, Ms. Carballo. The court does find probable cause. State what is your recommendation on counts 1, 2, and 3.
Your Honor, if I could just have one moment, I just want to make sure. I don't believe she has priors, but I just want to make sure.
No problem, I will wait.
She doesn't have any, Michelle?
I'll be looking.
Your Honor, in light of her cooperation that she had no priors, I would just be asking for bonds in the amount of $1,000 per count on 1 and 2.
Okay. And defense, what say you, if anything?
Judge, I know her family's there. She's going to be relying on her family to post her bond. I don't know if my colleague can inquire with the family to see if they can afford the $2,000 bond.
It'll be
three.
three, but okay. All right, ma'am, hi,
It's
welcome.
actually a $3,000 bond.
$1,000 bond.
Thank you for coming. You are?
I'm her sister, Masadi Garcia.
And the recommendation from the state is a bond of $3,000. Do you think you'll be able to post that for your sister?
I would have to try to figure that out.
Okay.
I
Through a
wasn't prepared 'cause I
bondsman.
didn't know how much.
That's okay. It's about $3,000. Usually you need about $300 in cash and $3,000 in collateral, or you can post a cash bond. Is that something that you think the family can afford?
And how does the collateral work? I'm sorry.
Well, you have to give them, I don't work for the bonds, but I can't tell you precisely, but generally it's something worth the value of what they're posting that you can give them title to or sign to them.
Where would she be living, ma'am?
She could come home with us if she agrees to that.
Okay, and so she would have a stable residence?
Yes, if she wants to come live with us. Yes.
And it's the state's understanding she has no prior criminal history. She does have a co-defendant. I don't know who was the brains of the operation here, if there were any brains involved. But the fact that she has no prior record, I believe her co-defendant does. He's also on this morning's docket. I'd ask the court to possibly consider pretrial release for Mr. Caballo, for Ms. Caballo.
Judge, if I could add to my colleague's argument, and hearing from the sister, I do see some hesitation as far as the financial ability. She did say, though, that she's willing to have her sister stay with her. If I could give you a little bit of background on Ms. Carbello, as the state did confirm, this is her first exposure to criminal justice system. She's a registered voter here in Broward County. She's also attending Broward College. She's a business major. She currently has a 3.8 GPA. She graduated from Somerset Academy. She's been residing in South Florida her whole life. Considering that her sister is there, Judge, we'd be asking you at this time to consider releasing her on pretrial release.
State, what say you?
One moment, Your Honor. Oh, please, I believe pretrial has some information.
Yes, ma'am.
Your Honor, based on the conversation I had with our sister this morning, if the court is inclined to releasing the defendant on pretrial, we're going to request a drug evaluation and random drug testing, because up until this point, the defendant's whereabouts by the family as far as where she was residing was pretty much unknown. She had moved out of the family's residence, and they had no idea where she was staying.
State, how do you feel about if I put her on pretrial release with an EM monitor and those special conditions?
I'd be fine with that. The only other request I'd make, Your Honor, is an order of no victim contact and no contact with our co-defendant.
Okay. Yes, ma'am? All right.
My understanding is from the
It wasn't
sister
stable.
that they always knew where she was.
Okay.
In addition to that, Judge, I could make a probable cause argument that this is an attempt. It says that the co-defendant was inside the vehicle, and he attempted to unlock the trunk so that she could enter the truck, but it never says that she actually did enter the truck. And the items were recovered in a backpack that the suspects were carrying. It doesn't say which of them were carrying the backpack. So I think there's even some probable cause arguments to make here as far as the strength of the state's case is concerned.
Ma'am, raise your right hand. Do you swear to tell the truth, the whole truth, and nothing but the truth?
Sir.
Yes.
Put your hand down. Tell me your name.
Masadi Garcia.
Ms. Adi Garcia, you're under oath.
Yes.
Anything you say in this courtroom has to be the truth. If it's proven that it's not the truth and you lie to this court, you could be accused of perjury, which is a felony punishable by 5 years in prison. Do you understand?
I do understand.
Do you have any reason to suspect that your sister has a substance abuse issue?
I don't know, honestly.
Okay.
I know that, as was mentioned, she has someone that she was with who...
Don't want to know about that. I just want to know, usually the family suspects if has she changed her behavior? Has she was, going to school, everything was fine, and then somehow fell in with the wrong crowd? Or you have any reason to suspect that there is concern that she has a substance abuse problem?
I would be concerned because of the situation right now.
Okay.
I'm just not really sure.
How do you feel
She
about...
has been going to school. She signed up
Okay.
for Broward College. Her phone call to me
Did she
yesterday.
successfully complete her last semester in school?
So she signed up and she started school this semester again.
I'm
She
not-
started back up.
I'm
She
not
had her
asking
AA
about
degree.
this semester. I'm saying last semester. When was the last time she was in school?
She took a break from school I don't recall
So
exactly.
do you know if she was
but
working or doing anything?
She has been working, right. The last I know she has not been working recently.
What
but
does
the last
recently
job,
mean to you?
Past couple of months or so,
Okay.
couple to a few months, but the last job she held, it was a steady job. She's very dedicated when she goes to work. She has very good work. Thank you.
Okay.
Sorry, Judge, I'm very nervous.
That's okay. All right.
She does have a medical issue. We actually had to take her to the ER. She suffers from rheumatoid arthritis, and so we actually took her to the ER just recently. She could barely walk. Literally could barely walk. So they had to give her shots. She's being treated by someone. So she wasn't working for a little while. But the last job she held, she has a very good work ethic about her. She's going to school. The phone call I just wanted to share the phone call she made to me yesterday when she called me from here to let me know she was here was, please contact my professor. I don't want to get dropped from the class. She had a homework assignment on Sunday. Our mom drove her there, to BC, to the library, to go ahead and complete her assignment. So I know she's very dedicated to that.
Right, the court's going to order pretrial release based on everything I've heard, but I am going to put her on electronic monitor, but a level 2. And I'm going to order no intoxicants and an abundance of caution and any random testing at the discretion of pretrial, so no set time, so just so that she doesn't violate her pretrial. But if there's no issue, it shouldn't be a problem for her. Okay? Good luck to you.
And Your Honor, as far as the request for no victim contact and no contact with the co-defendant?
Agreed. No victim contact in this case. It'll be the standard no contact, which means you have to stay 500 feet away from the victim's home, place of work, or school. And you have to stay away from the co-defendant in this case, which is?
It was Mr. Vega. It was Giovanni Vega. Is that it?
All right, so the other person accused of this offense, you cannot have any contact with that person, either directly or indirectly. Do you understand? Okay, that'll be a violation of your pretrial release, which means that you would end up back in custody. And that would be Mr. Vega.
Yeah, Giovanni Vega for the
Giovanni Vega for the record. All right, good luck to you. I hope that you do well and that this works out in the best for you, but whatever you do, don't violate your pretrial conditions. Good luck. Thank you for coming. It makes a big difference. We appreciate it. Lawrence Williams.
North Broward, Your Honor, that's a med reset.
Oh, okay. Thank you. Reset. Robert Murphy.
North Broward.
Okay. Mr. Murphy, good morning. You're here today for a violation of probation. You'll be held no bond until you see your assigned judge. That will be on September 6th at 8:45 a.m. Good luck to you. Gary Belizaire. Mr. Belizaire, you're here today accused of a traffic infraction for not having an attached registrations, driving while your license is suspended with knowledge, and a capias on a misdemeanor offense. For driving while your license is suspended with knowledge, bond in the amount of $500 on that count. Court finds probable, well, let's see. I had an issue with the probable cause on the, because he didn't indicate that he checked to make sure his license was still suspended. He says a telecheck advised that he had an active capias for the DWLS, and that he said my license, I did not have my license on him.
I believe the court can, I mean, I don't know if the clerk has a copy of his driving record. I think the court can
let me see.
take judicial notice. 'Cause it does mention he was driving. So.
Let's look at Belizaire. I don't have the driving record for Belizaire.
One moment. Oh, did you? Please go back. Belizaire. Did you do a search on him? We're going to check, Your Honor.
Yeah, can you just make sure it was suspended on that date?
Yes, Judge. Yeah, there it is. Look at the top right corner. just have to do DHSMB. That's. All right, you can just click on DHSMB. All right, Your Honor, we have his driving record here. I'm showing that it, as on May 30th this year, he was suspended indefinitely for a failure to appear.
And no reinstatement?
No reinstatement, also from,
Okay.
Your Honor, but what I can tell you is I do not see 2 prior DWLSs. So I would ask the court to find probable cause for misdemeanor DWLS and
Isn't that what, isn't, oh, because he was just third, so I'm gonna take out the
yeah,
third.
and
So just gonna do DWLS?
yes, and I just asked for the standard bond of $100.
Yeah, so not inclined since he was out on a DWLS for a standard bond, but defense, can you explain that? Because he has previous DWLS and then he has this DWLS. What is your recommendation?
Fine with the state's recommendation as far as standard bond, $100.
Yeah, I'm not inclined to do that. I'm gonna set bond in the amount of, that's recommended on what it thought it was habitual at $750, in light of the fact that he had a DWLS and then he committed the same offense allegedly, that he was out pending. Good luck to you, sir. Stephen Garrett.
All right, ma'am.
All right, Mr. Garrett, good morning. You're here today from we reset this from yesterday?
Yes, he said, Mr. Garrett said he was going to be hiring private counsel.
Is there counsel here for Mr. Garrett? There's no counsel here. Were you able to hire counsel for yourself, sir?
No, I was unable to do so, ma'am. I was hoping I could either get a public defender or a set bond so that I could hire a
Public defender is present in court. I will appoint them to represent you in light of the fact that you were unable to hire private counsel for your first appearance hearing. Would you like an opportunity to confer before we do his hearing?
I think that would be wise, Judge.
I'm gonna put this on recall so he can call you and confer with you, and then I'll do your hearing this morning. All right, I'll give you a few minutes. Yes, I'm gonna put that on recall, and I'll give you a moment and momentarily. Let's do Bobby Fields. It's the last one that I have on.
Well, we have 2 perfections or 3 perfections after that, but
Okay.
Ms. Fields is a medical reset, Judge.
Okay, and then let's do the others. Joshua Kelly.
Yes, Judge. I just need one moment. I have.
Mr. Kelly's here present, Judge O'May.
Thank you. For the record, what were we perfecting?
Your Honor, the issue was it didn't make any mention of the injury.
Oh, that's correct, on the serious bodily injury from yesterday. Thank you. All right, for the record, Mr. Romero, it was reset because it had reckless driving caused serious bodily injury. There has been a supplemental report filed indicating that he was sent to the hospital. There was a visible injury to his left shoulder. Pittman's shoulder was missing a small piece of flesh and was bleeding. Although he was still under examination by medical staff for possible internal injuries, his shoulder was visibly disfigured and will result in permanent scarring. He also was visibly in pain and was placed in a neck brace by medical staff. That was the additional information regarding the serious bodily injury. The court does find probable cause due to the fact that it indicates that there will be permanent scarring, which falls within the definition of serious injury, and therefore, didn't address bond on that?
No,
then?
we did not, Your Honor.
Okay.
Your Honor, I'm going to be, based on his history, Your Honor, if you need me to repeat that from yesterday.
Yes, I don't recall.
Yeah, I can certainly understand. Your Honor, Mr. Kelly has a pending resisting without violence. He has a resisting without violence in 2016, and in 2015, burglary of a dwelling with a battery, and he violated his probation. Based on his criminal history, that he has a pending case, and the
Did I address
allegation.
the pending case yesterday? Or
No, Your Honor, I don't think we did anything until I guess we were waiting for there to be finality one way or the other.
Okay. And the case number on the pending cases?
177559 MM10A.
All right. And he was and he's on probation?
No. He, I think it's pending. I just
Oh,
wanna
so
make
it's just, is he on pretrial release conditions?
That's what I'm checking to make sure, Judge.
Oh, because I didn't know PC and all of them. Got it. I see it now.
Yeah. Let me go see. Okay, what happened was, okay, it looks like what happened, Your Honor, he's on an ROR with the resisting without violence. I can't be certain what the circumstances were. They were attached to a felony at first, but, Your Honor.
Oh, I remember that discussion, yes.
As far as the bonds, what I would be asking for, considering count 1 is a first-degree felony, and the potential harm he put in multiple people's way, including law enforcement, and that the passenger's vehicle is injured, I'm going to be requesting a $10,000 bond on count 1. On counts 2 and 3, $5,000 bonds each. Should Mr. Kelly post his bond, I'm going to be requesting that he be supervised by pretrial release with a GPS monitor. I have no objection to level 2.
And what was his history again? Other than the one that was pending?
Another resisting without violence, 2016.
Oh, and the burglary battery?
And a burg bat with a VOP.
Okay. Defense, what say you?
Judge, unfortunately, Mr. Kelly, he's not working at this time. He was previously working at Kmart. Unfortunately, he lost his job. He was making minimum wage. He's 19 years old, been here in South Florida his whole entire life. At this time, he's homeless. However, his mother does live in Dania here in Broward County. She did inform me right now that his mother would allow him to stay with him. And he's asking, Judge, for me to ask the court, would you consider pretrial if pretrial can verify his address?
Based on his history of violence, the fact that he was unsuccessful on previous supervision in the community, and the seriousness of the allegations in these police reports, the court's not inclined to put him on pretrial release. The court's going to set bond in the amount, count 1, in the amount of $30,000, and on count 2 in the amount of $10,000. And
we can't hear you. Said 30 on 1.
30 on count 1, 10 on count 2, and 1,000 on count 3. PC on all counts.
Mr. Dixon.
And, Your Honor, as far as the state's request for a pretrial release GPS, my concern being the nature of the fleeing, that it was fleeing
Mr.
from
Kelly,
law
hold on,
enforcement.
Mr. Lender's still talking about your case.
So ordered. Pretrial GPS, should he postpone?
I'm fine with
Level
level
2. Christopher Carlton Dixon.
Yes, Your Honor, I just need one moment. Okay. Your Honor, I'm providing the court and defense counsel with a copy of the victim's sworn affidavit, and additionally, case law, Your Honor, Delgado v. State.
All right, remind me again while we reset it.
Your Honor wanted, the allegation was that he put his hand in his pocket like he had previously. I agree that it should not be robbery with a weapon. I argue that it can be considered strong-arm robbery by threat or placing the victim in fear.
Oh, we needed to have the threats.
Yes, Your Honor, and I'll let Your Honor read the affidavit in the case law before I continue.
Mr. Romero, just for your, since you don't have it in front of you. Are you ready, Mr. Reedy? Okay, then I'll wait. Okay. Is this the incident date of the 27th that we're dealing with, correct?
Yes, this was in response to this arrest, Your
Okay.
Honor. No, I agree it's not robbery with a weapon. I'm arguing for strong arm robbery.
Just with threats. So the only paragraph that seems relevant is the first paragraph, which I believe is the same paragraph that I had originally?
Well, yes, Your Honor. I just wanted to be able to provide it with his own words.
Okay.
I believe the case, I'm really relying more on the case.
All right, well, why don't you make your arguments to the case, because I
Okay.
really am having some difficulty with this
All
one.
right, Your Honor, well, I'm arguing based on the court, 4TCA holds that the controlling factor in a fear-based robbery is not necessarily the victim's subjective state of mind, but whether a jury can conclude that a reasonable person under like circumstances would have felt sufficiently threatened to accede to the robber's demands. Your Honor, this is noteworthy because based on what the loss prevention officer stated, a loss prevention officer, a reasonable loss prevention under the same circumstances, confronting the same person that you had previously confronted, taking the same exact actions that they took previously where they showed you a knife, reaching in the pocket, a reasonable loss prevention officer would be in fear. And that's why it's significant that I want to present in his own words, that he took the same exact actions that he had taken previously. He recognized them as the same person doing the same exact thing. I can't imagine how anyone, any reasonable person in that situation.
Do we have any verification of that previous incident, a report or police or anything, to verify what that allegation is?
Your Honor.
I mean, was that charged?
I don't know that a report was taken by Fort Lauderdale PD. I asked Detective Jones about it, but again, that's why it is relevant for probable cause purposes, Your Honor, that we have a sworn affidavit, under the same penalties of perjury that Mr. Ham provided to Detective Jones.
Defense?
Well, it doesn't appear as though there's any evidence that Mr. Dixon had a knife. I think the idea that he put his hand in his pocket and this person comes to a conclusion that it must have been a knife again is going well beyond the four corners of the probable cause affidavit or the affidavit. I don't see anything in here that indicates that this is any type of robbery with a weapon at all. There's no weapon involved. And we don't know if there was a weapon involved.
I understand your argument, State, but based on these facts, this is basically a theft that occurred at a store, and upon his exiting the store, he was attempted to be detained by loss prevention officers. The loss prevention officer has a fear when he saw the defendant put his hand in his pocket that he had a weapon, based on a previous encounter that he had. However, he never said any intimidating words. He never made any verbal threats. He never showed any weapon. There's no indication that he saw a bulge or anything that would support a conclusion that there was a weapon. And he was apprehended by law enforcement officers thereafter without a weapon. And so it has to be an objective determination based on the circumstances that a reasonable person would believe that there was a threat. And I don't see anything to support that conclusion other than this person's subjective fear based on his previous encounter. But objectively, there's nothing to support that conclusion. So the court does not find probable cause for robbery.
Your Honor,
I do find probable cause for petty theft, unless or theft.
Well, no,
I don't
that
know
was
what
covered by the grand theft that you already set the bondage.
Yeah.
I believe you set the bond.
So I already did that one. So I don't know that there's anything additional, unless that you can, I mean, it's resisting. Would you resisting a merchant or?
Well, one moment, Your Honor, if I could, I just want to check one thing. And he was charged with that also. Okay, and you already raised the bond on count 2 to $2,500. Your Honor, the only thing I would ask, because I don't remember if this was ordered yesterday, frankly, just no victim contact and no return to the Walmart on Broward Boulevard in Fort Lauderdale.
Any objection to that, defense?
No.
All right, so that'll be added to the counts that the court did find probable cause. The special condition of no return to the Walmart where this incident occurred, no direct or indirect contact with the victim in this case.
Thank you, Judge.
Thank you. All right, that leaves Giovanni Castano. Yeah, we'll put that on Rico last. Mr. Castano is where? Do we know where Mr. Castano is?
Michelle, were you able to pull stuff on Garrett?
Does anybody know where Mr. Castano is?
And you know, were there failures to appear out of state?
Judge, I get informed Mr. Castano was in court.
Oh, geez, but wasn't that what happened yesterday?
He should be in Maine.
Well,
Or what?
Brian, he's going to be ROR on count one. I don't have anything to add on count one.
Okay. All right, if he's going to be ROR'd on count one, I'd waive his appearance.
Okay, so ROR on count one, and the defense waives the defendant's presence. So ordered. All right, that's recall Mr. Stephen Reimer Garrett. Was he at Maine or no?
Yeah, it's Paul Ryan.
Oh, sorry. All right. Mr. Garrett, I do appoint the Public Defender's Office to represent you.
Judge, I've reviewed the probable cause affidavit in the case. And I've also spoken to Mr. Garrett about his ability to raise bond on this case. I believe the court is going to be setting bond on count 1 and count 11. Mr. Garrett basically works on the road, Judge, so he doesn't have a permanent location, but he does have a place he can live. He can live with his parents in Alabama. They own a house there that's worth approximately $300,000, and it sits on 5 to 6 acres. He's given me their phone number so I can call them to see if they'd be willing to put up a property bond for him if the court sets bond in an amount where they can afford it. And he would be staying in Alabama with his parents and returning to South Florida for whatever court appearances are required. He does own a Harley-Davidson. The value of that Harley-Davidson is about $12,000. He owns that outright. So that's something else that he could put up for himself to post bond. I don't believe his prior criminal history is extensive. I'd ask the court to put something around a total of $25,000 bond for Mr. Garrett so that he can bond out and come to court and answer to these charges.
State, what say you?
Your Honor, I'm going to be asking for $75,000 on count 1 and $75,000 on count 11. As Mr. Reedy stated, Mr. Garrett has no ties to the community. These are very serious allegations with, if convicted, potentially very serious consequences. Your Honor, I think also, in addition to just his lack of ties to the community, there are safety concerns for the community based on these allegations, Your Honor. I know pretrial has notes about his criminal history and if any failures to appear. Madam Pretrial, if you could please advise the court.
He has a 2012 failure to appear here in the state of Florida. There was also a 2012 adjudication for domestic battery, 2014 conviction for driving while license suspended. In the state of Texas, back in 1999, he was convicted for misdemeanor possession of marijuana. He was arrested on a domestic assault in 2007 that was dismissed, a robbery in 1997 that was dismissed, and in Alabama, 2013, he was arrested for driving while license suspended, disposition unknown.
And I'm sorry, there was a failure to appear, an arrest or failure to appear in 2012?
Yes, in Florida.
Okay, so prior failure to appear in this state. Additionally, Your Honor, normally in this kind of case, I might consider asking for a GPS monitor, which is impractical here since he doesn't live here.
Correct.
Which makes a monetary bond really the only way to act as a deterrent and to ensure his future appearance in court. The only other condition I would ask for, and I think a high bond is the only way to make sure that this is followed, is that he not be considering that a computer was used, that he not be in possession of any devices with internet access.
Mr. Garrett would be in agreement with the court if the court was to set a condition of his bond that he not have any internet access, including through a mobile phone or computer or any other electronic device. $75,000 on count 1 and count 11 is a very high bond. I don't know that his parents would be able to post that bond without speaking to them. I'd ask the court to consider something more reasonable in light of Mr. Garrett's own personal financial situation. He doesn't have any money saved up. He doesn't have a bank account. What he's got is a motorcycle and his parents.
All right. Based on the allegation, the police reports, the court does find probable cause on all counts. The court does set bond on counts through 2 through 10 in the amount of $1,000. On count 1, the court's going to set bond in the amount of $100,000. And on count 11, the court's going to set bond in the amount of $100,000. That is without prejudice of the assigned judge to review should the circumstances of parents warrant it. But at this point, the court feels that the only assurances that Mr. Garrett will remain in Florida and address these charges are if there is a high bond that would have a significant impact on his parents' home, should he fail to appear. Good luck to you, sir.
And I'm sorry. And I also meant to ask for an order of no victim contact.
No victim contact on any of the alleged victims in this case, and no access to a computer for Mr. Garrett.
All right, I'll call your parents, Stephen, and you're still entitled to go in front of your division judge to have this issue reviewed. You understand that?
Yes, sir, thank you.
Okay.
We're done.
All right, is that everything for this morning? Thank you very much. We're off.